Good afternoon, everyone. Thank you for joining us today at this session where we examine the impact of the new criminal laws on the rights of children. This session is being hosted by Enfold Proactive Health Trust and Project 39A of the National Law University, Delhi. As we know, we just stand 3 days away from the coming into force of the 3 new criminal laws, the Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023, and the Bharatiya Sakshya Adhiniyam 2023. This is a two-part series. In our first session, we will examine the new laws and how they will affect those of us who are working with child victims of offenses. In our second session, we will examine the implications of the new laws as they affect children in conflict with the law. We have two esteemed facilitators with us today, Monica Sakhrani and Medha Deo from the Fair Trial Program of Project 39A at the National Law University, Delhi. The Fair Trial Program is an initiative to provide legal representation to under-trial prisoners in collaboration with the State Legal Services Authority and the Prison Department. Monica Sakhrani is the program advisor with the Fair Trial Program. She's a lawyer and social worker with a PhD from TIS, Mumbai. She has over 30 years experience practicing law and teaching. She has practiced in the areas of constitutional, civil, criminal, labor, as well as family law in Chennai and Mumbai. She was also faculty at TIS, Mumbai at the School of Social Work from 2008 to 2016. Medha Deo is the program director of the Fair Trial Fellowship Program. She graduated in law from the Symbiosis Law School, Pune in 2008 and started her career as a corporate lawyer. She subsequently did her master's in law from TIS Mumbai in 2014. Before joining the Project 39A in 2018, she was working as a resource center for intervention on violence against women in Mumbai. I will now call upon Medha to begin, after which Medha will take over. Thank you.
Good afternoon, everyone, and thank you so much for joining for this session. Over the next 2 hours, Monica and me will try and address what are the changes which are relevant for victims, child victims, in terms of, and what will be a victim lens of looking at the changes in the law that have been brought in with the new acts. I'll be starting with the Bharatiya Nyaya Sanhita, which is a version of the Indian Penal Code, and Monica will be dealing with BNNS. We'll be dealing with parts of the Evidence Act because that is, we felt, more relevant for the children in conflict with law. So we will be touching upon some part of it today, but mostly the session on the Evidence Act and the Bharatiya Sakshya Adhiniyam will be tomorrow. Can I start sharing my screen?
Please go ahead, Medha.
I hope my screen is visible to everyone. So just in terms of tracing what has been the journey of and this holds true for actually all the three legislations. The new bill was introduced on August 11, 2023, which was then referred to the standing committee, and a certain number of changes were brought in with a second draft, which was introduced on December 12th. Some of the suggestions of the standing committee were accepted, and there was general consultation and suggestions that had come in, some of which were accepted, but most of them were not. And subsequently, the bill was passed in the Lok Sabha on December 20th and the Rajya Sabha on December 21st, 2023. And it has to come in force from the 1st of July, 2024. The statement of object and reasons of the bill said that the act intends to simplify procedures and streamline provisions. The messaging from the government that had gone out was also to say that the law is a colonial remnant, and the exercise would be to decolonize the law. However, looking at the way the changes have been affected and the changes that have come in, it almost is far, far from being decolonized. Sorry, I'm facing some, yeah. So just to summarize, what were the kind of the changes that were brought in? So there were obviously addition of new provisions and offenses. Provisions were rearranged in terms of bringing them in distinct chapters, which was very different from the way it was done under the old Act. For 33 offenses, there have been enhancement of punishment. And for another 83 offenses, there have been enhancement of fines. For 23 offenses, some of which are newly introduced and some of them were existing, there has been a minimum mandatory punishment prescribed. And we look at some of the ones which are relevant for child victims in the subsequent slide. And about 20, only 20 sections were repealed or omitted in terms of what has been included from the old Act. As we can see, most of the provisions of the old Act have been included in the new Act as well. So, what are the changes which are specific to child victims? So, to start, Gopika, can you please mute yourself?
Yeah, we will just request all of you to remain on mute. Thank you.
So to start with, there's a definition of child which has come in the Act, and it defines child as any person below the age of 18. So because of this, there's consistent use of the term child as opposed to minor or child of this age, child of a certain age, child below 12, child below 16, which was different in different sections earlier. So now most across all sections, the term child has been used, which is understood as a child who is below 18 years of age. So that is also to bring in harmony for a lot of provisions with special legislations like POCSO. Another new provision which has been added in the Act is Section 95, which talks about the offense of hiring, employing, or engaging a child to commit an offense. And this offense is, sorry. So any person who is charged with hiring, employing, or engaging a child to commit any act which in itself is a criminal offense would be punishable with a minimum punishment of 3 years, which can be extended up to 10 years and with a fine. Also, there would be punishment if the act for which the child was hired or engaged, if that act was also committed, then such adult will also be liable to punished with the punishment which was for the act, the illegal act for which the child was hired. This specifically includes hiring for sexual exploitation or pornography. And in that sense, there have been concerns around how this will play out with relevant sections in the POCSO. In addition to that, Section 96, which already existed in the old Act as Section 366A, which spoke about procuration of a minor girl. Section 96 has made that term gender neutral, and the new section reads it as procuration of child. So both these sections look at the victim, the child victim, as either a boy or a girl. But there will be interplay with POCSO, but it's to be read harmoniously. Another change that has been brought in is in section 143, which talks about trafficking, and the word beggary has been used expressly in explanation 1, which was not used in the old Act. In terms of punishment and the other definitions of trafficking, everything remains similar. It's only that in addition to exploitation, etc., beggary has been added in the explanation. Section 99, which is equivalent of the erstwhile section 373, which talks about buying a minor for the purposes of prostitution. If you'll notice, this new section uses the word child, and there is a minimum mandatory punishment prescribed of 7 years. And the maximum punishment has also been enhanced from what was earlier 10 years to now 14 years. So there has been... The next section, which has substantial changes, is in the kidnapping of minor for purposes of begging, or kidnapping of child for purposes of begging in the new section. Again, a mandatory punishment of 10 years has been prescribed. And the maximum punishment, which was 10 years earlier, has been increased to life imprisonment. In terms of the same section where a child is maimed for the purposes of begging, the minimum mandatory punishment has been enhanced to 20 years, and maximum punishment from has gone from life imprisonment to imprisonment for the remainder of person's natural life. So this in ways takes away the state's power of remission, where the act itself is specifying mandatory punishment till the remainder of person's natural life, and it has interplay with provisions in the CRPC in that sense. So in addition to these sections, which were talking specifically about children as victims, there are other provisions in the law which have seen changes, and which will be relevant, or which will have interplay with special legislations protecting children. So, for example, the age of consent for marital rape, which was in the IPC exception 2, mentioned as 15 years, has now been made to 18 years. And this takes care of a lot of confusion and judicial inconsistency about marital rape, and how accused persons in marital rape have to be treated under POCSO vis-a-vis the IPC. But hello. It also creates that risk of so at the Fair Trial Fellowship, we see a lot of cases where there is marriage, socially sanctioned marriage, which may be within the age gap group of 15 to 18, or sometimes where the girl child is even less than 15 years, and there has been consensual relationship, which is sometimes used by the police as a means of just high-handedness to arrest persons or over-criminalize people who are in socially sanctioned marriages. So this ambiguity was it used to create a scope for taking benefit of the ambiguity, and that will entirely go away, even in cases where it has been consensual and socially sanctioned relationships. The other change that has come in, which will be relevant for child victims, is the age of victim has been increased to 18 years in provisions on gang rape of women. Earlier, it was two provisions, 376DA and 376DB, one of which prescribed sentencing for rape of women under 16 years, and the other one for women under 12 years. It has now been made consistent and is punishable with death, even where the victim is less than 12 years of age. Victim is more than 12 years of age, which was not the case earlier. So looking at other changes which will be relevant to... Section 117, which talks about voluntary causing grievous hurt. Another section which might be read or which might be applied in cases of child victims, along with special provisions of special legislations. The mandatory minimum punishment has been made 10 years, and it can extend to imprisonment for the remainder of a person's natural life, which in case there is causing hurt, which causes a person to be in permanent disability or in persistent vegetative state. So this category of hurt was not recognized in the previous act, and it can be made applicable even in cases of acid attacks or even in cases of child rape, where there has been a lot of brutality with the child. The provision on kidnapping also has made mandatory. It has made kidnapping of all children as an offense, as opposed to the earlier prescribed age of 16 for boys and 18 for girls. This was earlier seen as kidnapping from lawful guardianship, which was section 361, and is now part of a combined section of kidnapping. And it uses the term children as opposed to separate terms for boys and girls. There's also a provision on mob lynching, which this act introduces, and will be relevant in cases where children are looked as victims in cases of caste violence or other kinds of violent scenarios. And this introduces punishment for murder caused by mob lynching with death or life imprisonment and fine. Another important introduction in this act has been introduction of the idea of organized crime, which was earlier applicable in Maharashtra and Gujarat through special legislations, and some states adopting the MACOCA or the Gujarat OCA. So this criminalizes continuing unlawful activities like kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, or illicit goods or services, human trafficking for prostitution or ransom. Now, as we would see, a lot of these activities become relevant in cases of child victims, especially trafficking, prostitution, and cyber crimes. So there is a recognition that these kind of offenses are run by cartels, and there are cartels, and there needs to be a special regime for looking at these cartels. But the law has now brought it in from the scope of a special legislation to a more general legislation. There has obviously been concerns around the way these sections are worded, and they do not take into account a lot of protections which were originally in the special legislations. At the same time, there is a lot of vagueness. Like, for example, what constitutes unlawful activities is an illustrative list, and these 10 items that are mentioned here is an illustrative list. And therefore, it is left open to the interpretation at the first instance of the police of what would constitute an unlawful activity. In addition to that, the way the punishments have been framed, it is very, very wide. To include people having even the slightest of connections with the organized crime cartel, which exposes a lot of victims themselves. And in all cases, they might not really be child victims, but specifically in cases of trafficking, there might be victims who have been trafficked as children and have grown as adults, who will be very, very vulnerable to arrest under different counts of how organized crime is seen. So for example, if we look at punishment, so the first is whoever commits in any organized crime, and if there is death of the victim, the punishment is death or life or plus fine up to 10 lakh rupees. And if there is no death, then it will be 5 years to life. However, so if we see if there is any kind of abetment, conspiracy, any kind of connivance, then that makes a person liable to punishment of 5 years up to life. Similarly, for member of syndicate, the punishment is again for 5 years up to and up to life. The trouble is that these terms are not defined terms in the Act, and how it will play out, how it will pull in victims alongside those of the cartel operators remains to be seen, and will remain a concern. Similarly, harboring or concealing any person who is part of an organized crime group is an offense. Possessing property from organized crime or from the proceeds of an organized crime is an offense. And any possession of unaccounted property by a person who is understood as a member of an organized crime group is also seen as an offense. So the punishments are mentioned here. In addition to these provisions, which are more general move to enhance punishments, and from a victim lens, what can be taken benefit of is, hello, am I audible?
Yes.
So there are provisions on false evidence and offenses against public justice, which are from section 205 of the current legislation. I've not mentioned the section numbers. But sorry, it starts from section 200, which talks about punishment for non-treatment of victim, public servant framing an incorrect document, looking at cases where people are absconding to avoid, this is section 206, absconding to avoid service, preventing service of summons. So some of these provisions which are related to the justice procedure or the procedure of the trial itself, which causes undue delay and undue trouble to the victim, these have been enhanced and they can be taken benefit of. But the changes are only in the nature of enhancement of provisions. There have been no clarifications, no additional definitions, no additional recognitions in that sense. Chapter 13, which talks about contempt of authority of public servants, there are enhancement again in the same nature. Another provision which is relevant is death by negligence, which is section 106 in the current legislation and used to be 304A in the old legislation, where the punishment is now enhanced to 5 years as opposed to 2 years, which was before. The other provisions, which section 125, 126, 31, so these are related to offenses against the body, which will be relevant for as additional sections in cases of violence against children or relevant to cases of child victims, in addition to special legislation. So wrongful restraint and confinement punishment has been enhanced. Assault, and we already saw grievous hurt in 117 earlier, which was dealing with the victim being reduced to a vegetative state. And any assault to wrongfully confine, section 135, also has been enhanced. Just reflecting on some other changes sorry. just reflecting on some of the other changes which the Act has come with. Section 377, which dealt with unnatural offenses, has been repealed. And there is no equivalent section within the IPC to protect male and transgender victims against any kind of rape or sexual abuse. The term transgender also has been defined specifically, and therefore transgenders cannot be read into the definition of women, which just leaves with, while the Act claims to be gender neutral, mostly in all offenses against the body, it has been in all sexual offenses, it has been understood to have a male offender and a woman victim. That is how the construction of the sections have been across. Only sections 76 and 77, which are replica of the old provisions, which is use of criminal force to disrobe and voyeurism, they are offenses where the offender is gender neutral. Other than that, all provisions, especially in case of sexual offenses, look at only a male as an offender. So coming to the conclusion, by and large, the Act retains language of the IPC, and there are concerns of expansive criminalization and enhancements of punishment. While it does take care of a lot of concerns one had around the way there was interplay between the POCSO and the IPC, there is still confusion about what will be police powers, and we'll see that when we look at the CRPC in terms of how the laws have to be harmonized. In harmonizing the marital rape provision and other provisions with POCSO is a welcome change. That is, yeah, I'll just conclude. Thanks.
Thank you, Medha. I'll now call upon Monica.
Hi, thank you. I'll just share my slide. Yeah. So good afternoon, everyone, and thank you for this opportunity. I'll be dealing with the provisions of Bharatiya Nagrik Suraksha Sanhita, which is replacing the Code of Criminal Procedure. I'll be looking at some of the sections today, and tomorrow I'll deal with the JJ Act in particular and the Sanhita. So the thing is that basically this has more sections as compared to CRPC, but actually in reality, sections which were included subsequently, such as, Section A, like for example, 433A, 436A. So those have been, and some chapters which had like on plea bargaining, etc., which had been introduced subsequently had been given, like say 463A to whatever. So those sections have been, renumbered. So the number, actually the code isn't much larger than or longer than the CRPC, but it has more, it has this, the section numbers are more because of the renumbering. And unlike the Indian Penal Code, the structure is, the same as what the CRPC structure was. So before I, kind of deal with the changes, we have to, the CRPC at the time of independence was the CRPC of 1898. And it had, the structure of the courts, the system, the hierarchy, magistrates, sessions courts, high court. So the structure was very similar. the differentiation of offenses into cognizable, non-cognizable, bailable, non-bailable, sessions triable, magistrates triable, summons cases, warrants cases, where was already there in that code. And but the code also had a few elements which were mostly repealed in 1955. So there was an Amendment Act in 1955 which did away with a few things like, there was no clear-cut, there was no clear-cut division of which, like today we understand that, if it's a theft case, it will be tried in a magistrate's court. If it's a rape case, it will be tried in a sessions court. That clear-cut division was not there. So there were three types of trial courts. They were the magistrates courts, the sessions courts, and the high court. So the high courts also could try any of the cases. So it was also a trial court. So what in 1955 was done was, the trial courts were basically the magistrates courts and the sessions courts, with the high court having the power to, call for any matter and try it itself. So the high court still has the power to try a case, but by and large, under the CRPC, it's not given. And the schedule also, Schedule 2 was made into Schedule 1, which, all lawyers refer to because it gives us the overview of where the court is, whether it's a bailable offense. It lists out all the IPC sections and tells you whether it's a bailable offense, or a cognizable offense by which court triable, etc. So that was done in a very clear-cut way. The other really important change which came about, and I really want to say this because of this whole decolonization debate, is that actually there was a differentiation in the trial between Indians and foreigners, especially whites. So there was there were different sets of rights, etc. And that was done away with. So everybody, no matter who you are, you will go through the same process in the court. You have no additional rights, or whatever additional rights are there for everyone. So that was a major change which was brought about by the 1955 amendment. And then in 1973, as we all know, the CRPC was completely recast. But even in the recasting, the basic structure of the courts remained the same as it was there in the 1898 law. And most importantly, the powers, like for example, 125, which many of us are familiar with, that a woman can file for maintenance under Section 125 of the CRPC. Earlier it was 488. That continues. So and preventive power of arrest. So the police could arrest anybody who has not committed any offense, just to prevent that person from committing an offense. Removal of nuisance, Section 144 that we all know. The whole chapter case, Chapter 8, which deals with chapter cases, that is, anybody can be asked to give a bond of good behavior. So these continued, these were seen as colonial relics, and which gave a lot of power to the state, but they continued, and they still continue in the BNNS. So overall, the structure is the same, but what it does is updates the law in certain ways. One is to keep up with technological changes. So, for example, now summons can be issued electronically. So, so that has one of the things. Then the other thing is that whole question of delay, which it's tried to kind of address by setting timelines for certain stages. So there is, unlike POCSO, which has like the trial should be completed as far as possible within a year, or under JJ Act, which says within 3 months. This doesn't have that, but it has, at certain stages, it gives certain timelines. But what it doesn't tell us is what happens if these timelines are not met. So that is one thing that we will have to kind of see how it pans out. Because there have been many judgments, there have been judgments of the Supreme Court which say that, judgments have to be passed within a particular time, bail applications have to be decided within so many days, etc. but they're not. And I, for one, wouldn't blame the judiciary for the delays because they are really overburdened. The question of delay is not going to be solved by just putting timelines. You need to put in infrastructure in order to actually address that. That is another issue. And the other is there's been some expansion of victims' rights.
There's Pondicherry at the radio.
Yeah, this has been happening. Is there's some question on the chat? Okay. Okay, I'll deal with that. Bharti's question on unsoundness of mind. So there's been this expansion of victims' rights has been happening since, I mean, we've seen it especially in the last 12 years, but it's happened even before that, especially, when changes were introduced with regards to even shifting of burden of proof in the Indian Penal Code, etc., which was that, especially in the cases of rape, where a woman says that that the sexual intercourse was without her consent, and the court will presume that it was. So this came in the Indian Evidence Act. So there has been some kind of an expansion since 1983, if one looks at even the changes in the rape laws and when they came about. So the change in of nomenclature from unsoundness of mind to mental illness. So there is a chapter in the in the CRPC, and it's there in the BNNS, also identical, except for one provision, which is that it talks about people who are who have unsoundness of mind, who are not, who are not going to be tried till they're found mentally fit for trial. So the provision is that if somebody is incapable of understanding what is happening in the court and incapable of making a effective defense for themselves, they should not be tried till they are all right. So the issue over here, and actually, as a lawyer, I've also dealt with it. We're still dealing with it in our organization also, is the question that many people actually, they have an intellectual disability, which because of which they will never be able to recover. So what do you do? That person will never be fit for trial. And right now, the provision is that you can be released on bail, provided somebody is willing to take charge of you. But what happens to your case is that the judge will wait till you're all right and then try you. But what if you're never going to be all right? Then the question is that you will have to move at least in Maharashtra, the criminal manual makes a provision for you to make an application to the state government, asking the state government to withdraw your case from prosecution because you're never going to be fit for trial. And then the state government has to take that decision. So that provision still continues, so there are certain lacunae in law which could have been really addressed. What if a person is never going to be fit for trial, but that it doesn't address. The other question is that mental illness has been defined as per the Mental Health Care Act, which defines it as a form of emotional distress, etc. It doesn't take into account what we call an intellectual disability, or which was earlier called mental retardation, which is a condition which you're not going to be recovering from. So earlier, unsoundness of mind covered both these cases, so you could also argue saying that a person is, say, for example, having a intellectual disability and will not be able to stand trial. But right now, the interpretation of the law is such that, the section is worded such, but I'm sure, sooner or later, the courts are going to deal with it, and they'll have a solution to the issue. So because this is going to come up sooner than we anticipate as an issue. Oh, sorry, I haven't done a slideshow. So this is going to come up sooner than we anticipate. And that is an issue which will have to be dealt with. The other, major change is that medical and forensic expert testimony has been dispensed with unless the accused disputes the evidence. So some of the important provisions are that the section on which defines investigation says that if the provisions of any special law are inconsistent with BNNS, then special law will prevail. So that has been clarified that if, say, for example, if there is a provision in POCSO or in JJ Act, which is contrary to the provision of BNNS, then that will prevail. The question that actually comes up is when two special laws have provisions which are different from each other, then which one will prevail? That is the real question, which actually sometimes comes up, and that is the disputed questions. The definition of victim is now includes the guardian or the legal heir. The hierarchy of the courts remains the same. So earlier during the time of the British, there were presidency magistrates in presidency towns. And post 1973, the concept of metropolitan magistrates were introduced in metropolitan areas. But what the new law does is it does away with assistant session judges and metropolitan magistrates. And now all magistrates are judicial magistrates. Of course, we still have the special executive magistrates, and we have the executive magistrates who are part of the administrative structure. They still continue. But so now you have additional sessions judges and sessions judges, and you have JMFCs and JMSCs. So second class and first class distinction still remains, though actually it should have been done away with. But the punishment also, the structure of punishment for all remains the same. So you have, like, for death penalty, it has to be confirmed by the High Court still. Up to life imprisonment can be given by the sessions courts, up to 7 years by the chief judicial magistrate, and the fines 3 years by the JMFC and 1 year by the JMSC continues. But the fine amounts have increased to 10,000 and 50,000 for the two categories. But I haven't come across any JMSCs. I don't know if any of you all have come across. So that could have actually been done away with. Then, of course, special executive magistrates, there was a Supreme Court judgment which said that, they should be removed. And then after that, SCOs were appointed. And we all know that these are mostly, political postings, and they are non-lawyers or non-judicial, not from the judiciary. But now even a superintendent of police onwards can be appointed as a special executive magistrate. The issue with this is that, by and large, identification parades are held by SCOs, or they were held by special executive magistrates. But, and the idea was for having a distinction between the administration and a judicial or an independent body, which, this definition is going to, okay, thank you. Yeah. So Mahesh Menon said the JMSCs are still there, so thank you for that. So that is something. So, the whole idea of having a SEM as an independent body, now you're actually, the police itself will, and the identification parades were not supposed to be done by the police. They were supposed to be done by an independent body. It was not supposed to be done in police stations. There are hundreds of, there are umpteen judgments on that. So now, one kind of doesn't know what is going to be the implication of this when it comes to investigation, and especially of identification parades. And then, as I was saying, summons can be given even electronically. So one has that provision which has come in. And there has been the setting up of the Directorate of Public Prosecution. It's a demand which was made by several law commissions, and it was set up. And So now you continue to have the Directorate of Public Prosecution, but what it's generally set up at the state level. Now it's come down to even the district level. So you have, and this is really important because and this is independent of your public prosecutors, your special public prosecutors, your assistant public prosecutors. So victims still have the right to get a special public prosecutor appointed in a matter which they want, so if you don't want to go in for the regular public prosecutor, you can always ask through the state government, you can ask for a appointment of a special public prosecutor that continues. Their experience remains the same. But the Directorate of Public Prosecution will be set up now in every district. And the experience required is that the deputy director, the sessions judge with or advocates with 15 years of practice will be the director or deputy director, and judicial magistrates of the first class or advocates with 7 years of practice are eligible to be assistant director, assistant public prosecution directors. And the director of prosecution has the responsibility of monitoring. So the director remains at the state level. The other two are there at the district level. So the director has the responsibility of monitoring all cases punishable with up to 10 years or more than 10 years of imprisonment, expediting these trials, and giving an opinion about filing of appeals. The deputy director has to examine and scrutinize police reports. So this whole thing of the investigation done by the police will now undergo scrutiny by the Department of Directorate of Public Prosecution, and the deputy director will examine all police reports in matters which are punishable between 7 years to 10 years for ensuring the speedy disposal, and the assistant director to monitor all cases punishable with less than 7 years. The issue over here is that if we have the director only at the state level and not at the district level, and if he's supposed to monitor cases punishable with over 10 years of imprisonment, those punished with death penalty, etc., then how are you going to actually practically enforce that provision is something that, and one doesn't know actually about how much it's actually going to be effective in terms of even monitoring of investigation and trials. So that we'll have to, see how it goes. Now we come to FIR and investigation of offenses. So we all know that an FIR, so FIR is nowhere defined in the CRPC. It continues to not be defined in the BNNS. But the thing is that an FIR, we all know that need not be filed. There are Supreme Court judgments which say that even if I go to the wrong police station, the police is supposed to register my FIR and then as a 0 FIR, and then send it to the police station with the jurisdiction to investigate the offense. And there the case will be numbered and investigation will be carried out. So that has been recognized in the BNNS by saying that an FIR can be lodged, because I think many of us have gone through this experience of being told that this police station, despite the 0 FIR and knowing that it is there, we've been told that, you'll have to go to some other police station. So that it's specified over here in the law itself that you cannot do that. Electronic FIRs have been there for quite some time, and they have to be taken cognizance of, but they have to be signed within 3 days of actually filing. So if I register an FIR online, then I have to go to the police station within 3 days and sign it. The other very major change which has actually come about is that so we know that there have been also cases where police don't immediately register FIR, they don't immediately arrest the accused, and there has been this whole tendency of holding what we call a preliminary inquiry to see if a prima facie case is made out. And there was a Supreme Court judgment, Lalita Kumari's case in I think 2013 or 14, which actually stated very categorically that you cannot have a preliminary inquiry before registration of an FIR or before investigation. You have to carry on an investigation, because suppose I register an FIR and the police on investigation finds that it's a false case, it has the option of actually filing a report saying it's a false case. The whole purpose of investigation is to investigate the veracity of my complaint, apart from the fact that, I may say that, oh, my house was broken in when I was not there. And so the police will come and they'll investigate and they'll try to find out who the perpetrator is. So there is that level, but generally a preliminary inquiry was really looked down upon, because as we all know, it was happening mostly in 498A cases and in cases where women were victims. There was a reluctance to actually register the offense and try and arrest the accused. So in Lalita Kumari's case, they said that for certain offenses, including 498A, what you can do is you can see whether prima facie case is made out, just that, and no, not a prima, whether an offense is disclosed. So you just have to find out whether an offense is disclosed or not, and you are not going to look at whether there is truth or any kind of a this thing in the case. But now this is really common, which is contra. So there are many changes which are actually contra to Supreme Court judgments, and this is one of them. But it has to be done with the permission of the DYSP. So that is, we'll have to look at it. The other change, which is a good change, is that we all know that when we go to register an NC, then it's registered in a register. And now it is, and of course, the police can't arrest or take cognizance of the case, but now they have to submit it every fortnightly, the daily diary in which they register all the NCs to the magistrate. So now there's going to be also a judicial record of the fact that an NC has been registered, instead of, only a police station record. And so, there will be some kind of, it'll be easier for the victims. The other issues which are there is that one is that, it provides for forensic experts to visit crime scene in cases punishable with more than 7 years. But they've said that the state will notify within 5 years, and then, the infrastructure has to be put in place. But the important change which has come is that when a magistrate receives a complaint against a public servant, so we all know that there was this, there's another, no, it's not when the DYSP agrees to file a FIR. It is when he will have to he'll have to discuss the case. If it is less than 7 years, he will have to tell the IO will have to tell the DYSP that according to me, a preliminary investigation inquiry is required. And then the DYSP will tell him that, okay, go ahead with a preliminary inquiry, and therefore he will hold. Otherwise, he's supposed to register the FIR. Yeah, I think Aditi, that's how I understood the section. So if there is a complaint, we all know that there is a section 197, which is again a colonial relic. And we know that a case cannot be registered against a public servant for anything done in the course of their duty without sanction to prosecute that person. But here what is written is that if there is a complaint against a public servant doing something in the discharge of their duty, then the magistrate, so 197's provision still continues. But here, even with regards to investigation, if a victim is not happy or is filing a complaint, etc., or an accused is filing a case saying that I was illegally detained in the police station, then the the magistrate can take cognizance only after calling for a report from his higher officer. So the public servant's higher officer. So if X is the complaint is against X, then X's higher officer will have to submit a report regarding the incident, and then X will be heard by the magistrate. and only after that can the magistrate take cognizance of the case. So I don't know how this is going to, because if it is during the discharge of the duty, so anyway the bar for cognizance without sanction to prosecute will remain. So one needs to kind of figure out what this additional barrier, how it's going to pan out, because if there is already a sanction to prosecute, then where is the requirement for this? Of course, the sanction for prosecute, the good news is that if it is not given, then within 120 days, then it will be deemed that the sanction has been given. So that is a positive change which has come about. So audiovisual recording of statements to police and searches, we'll be dealing with these in a little detail. Yeah, there is a question.
Hi, sorry, I'm just going back a little because
Yeah.
I wanted to understand it a little better. Will the IO have superpowers then to agree whether the preliminary investigation is required or not? And if they want to make trouble for the complainant, then will more trouble be created for the complainant? So
Yeah.
this is not like an FIR has to be filed regardless.
FIR has to be filed, but the investigation is what is really the issue is really the investigation. So they will register the FIR, but they will say we are having a preliminary inquiry, and after that we will start investigating the case. So they can do that. The thing is that now under the new law, within 90 days of registration of FIR, the police is supposed to intimate the first informant. Of course, the first informant need not be the victim, but has to intimate the first informant about the progress of the case. So you have your remedies, similar to 156(3) will still be there. You can go to the High Court and you can challenge it. So it is going to lead to some kind of a litigation. My feeling is that, okay. Yeah, so you've been asked to hold your questions, but since you've asked, I'll just deal with it. My feeling is that a lot of it's not going to be in every case that a preliminary investigation is going to be held. And sooner or later, the Supreme Court is going to actually come up with certain guidelines. But of course, within 7 years, if an offense is punishable only up to 7 years, anyway, there's a provision which says that you cannot arrest the person. So that provision still continues. That is still anyway there, but also within 90 days, you as a first informant will be intimated as to what is the progress of your case. So that right has been given. Yeah. So audiovisual recording of statements to police and searches has to be done. We'll go into it in a little detail. We all know that there's a provision which says that women, children, who are sick or infirm need not be called to the police station for recording their statements, and the police has to go to their place of residence or any place they are comfortable in for recording of the statement. But here, of course, women, all females are included over there, males below 15 years or above 60 years, or persons with mental, physical disability or illness. Their statements have to be recorded in their home, except if they're willing to. So this proviso has been added. But if they're willing to come to the police station, then it should be recorded over there or any place within its jurisdiction. So earlier, this option was not there. You were supposed to go to their place and record it. But now this option has been given that if I'm willing to go to the police station, then it should be done there. So in sexual offenses, as well as all cases punishable with 10 years or more, the judicial magistrate will record the statement of the witnesses. Then, the most controversial, proviso which has been included is that we all know that there are two types of custody. One is police custody and the other is judicial custody. And generally, the 1973 code actually brought in a limit to earlier there was no limit to the time taken to investigate and file a charge sheet. So the police could do it at any time, and several law commission reports kept saying that there should be a time limit for completion of investigation. And so the 1973 code brought in the concept of 60 days for offenses punishable with 10 years or less, and 90 days for more than that. So that proviso still continues. And if, it's not, if investigation is not completed, then you got the right to default bail, and that continues. And the other thing is that within that period of filing of charge sheet, you have you can be granted custody. If you're not released on bail, then you're in custody, and generally police custody cannot be more than 15 days, and it's generally given in the first 15 days of your arrest, and subsequently you're sent to judicial custody, which is jail. So there are two things that this changes. One is that there's a specification which says that police custody means lockup, police station, and police lockup, and judicial custody means being in a prison. So this whole house arrest and things like that, or you're kept somewhere else, that provision is, there's a specific proviso made over here. What is the meaning of police custody and what is the meaning of judicial custody? The other is that they say that if it's a matter which has to be in which the police have up to 60 days of time to investigate, then within the first 40 days, you can be granted police custody at any time. So, and if it is the investigation time is 90 days, then it can be granted, police custody can be granted at any time within 60 days. There have been many judgments which actually have brought into question the issue of, can police custody be granted after the first 15 days, or should it be granted only in the first 15 days of your arrest? And by and large, it has been held that it should be within the first 15 days. There are judgments in which they've said that if the accused has been avoiding, by going and sitting in the hospital. So here now, again, we don't know that if suppose I'm very sick when I'm arrested and I'm in the hospital, then will that be considered period of custody? Because we know that under law, we have something called set off. So if for example, if I have been in jail for 1 year and I'm sentenced and I'm punished to an imprisonment of 1 year, then my 1 year in prison gets set off against the 1 year which has been, sentenced against my sentence, and I get out of jail immediately. So now we don't know whether, if suppose I'm very sick and I go to the hospital or I'm admitted in the hospital, then will that be counted as my period of custody or not? These are questions which are going to be litigated because we still have the same constitution. So constitutional provisions are going to be used to question these or challenge these provisions. That again, over here also, but the Supreme Court over the years has been leaning more towards, allowing for grant of custody even subsequently. So that we'll have to see what is the outcome of that section going to be. Then further investigation, we all know that after charge sheet is filed also, one is that there's 90 days. So the only right that the accused gets is after 90 days is or 60 days, you get released on default bail. But the investigation can continue and the charge sheet can be filed. Several times charge sheets are filed and then the police say that we haven't completed investigation. We need to further investigate. There are certain things that we need to still inquire into, and then they get further time to investigate. So here there's been a kind of outlier put in for further investigation. That is that with the permission of the court, it has to be completed within 90 days, which may be extended again, but you need the permission of the court. So that is the proviso. So this, with technological advancement, this whole audio recording of evidence has started, and POCSO also states very clearly that victim's statement has to be recorded, and 164 CRPC, which talks about recording of confessions and statements of witnesses to the magistrate, also provide for audiovisual recording. But 164 today only if the statement is made to the magistrate, then only if it is a statement of a witness who's permanently or temporarily, physically or mentally disabled, or if it is a victim of crimes against women, only in those cases is the audiovisual there. So now the thing is that you brought in a law which says that if there is any offense which is punishable with more than 10 years, then the statement of that witness should be recorded by the magistrate. But you've diluted the provision for audiovisual recording, and you're saying that only in certain cases will the statement made to the magistrate be audiovisually recorded. POCSO's provisions will still apply, and because POCSO, special law will prevail, and anyway, crimes against women, it has to be recorded. The other option which is given is that if it is a statement made to the police, then the police also have the option. They may record it by audiovisually, but what they've said is mobile phone. So I found that a bit strange. That why is why are you saying preferably by mobile phone? Maybe because it's there with everyone, but that gives rise to a huge possibility of tampering. The other thing that is, if there is any search or seizure made, that has to be, recorded by audiovisual means. And that recording has to be sent without delay either to a district magistrate, subdivisional magistrate, or judicial magistrate of the first class. So the option is there that it has to be sent to one of the three. How that pans out, we don't know. Again, test identification parade involving witnesses who are permanently or temporarily, physically or mentally disabled has to be, audiovisually recorded. Then, of course, there's collection of forensic evidence has to be audiovisually recorded. There has been a deletion of some of the provisions which actually asked for an audiovisual recording. That is, one is, confessions by accused. It doesn't exclude search of persons arrested and places of arrest. So that does not covered under. So when an accused is arrested, the whole possibility of torture and ill treatment, that to actually exclude that possibility, it would have been good to actually include even that audiovisual recording, especially if you're doing it by mobile phones, which everyone has. Excludes spot inspection, inquest proceedings, which were covered, postmortem proceedings, as well as discovery and recovery. So if anything is recovered or discovered from the accused, like for example, the weapon, etc., or the dead body, that is not included, So I mean, I'll let you all read between the lines as to why it has not been included in this. So POCSO will still prevail. So there's been an expansion of victims' rights. As I was saying, that one is that you have the right to get the copy, to be informed within 90 days as to the progress of your case. The witness, the first informant always had a right to the FIR. That continues. Also, now the right to get a charge sheet is there, provided the victim is represented by an advocate. So if you're not represented by an advocate, then you don't get the copy of the charge sheet. Otherwise, if you have a lawyer, then you will get a copy of the charge sheet. Then victim has a right to be heard before withdrawal of the case from prosecution. Earlier, this right was not there. So now this right continues. Right to be heard right to file appeal, right to be heard during bail, etc. still continue. When an accused files for discharge of a case, also the complainant has the right to get notice prior to the discharge application being filed. After the discharge application is filed, prior to the discharge being being decided, and that is there. The other is that we have see, the thing is that the question is that victim cannot ask for a charge sheet. See, you can ask for a charge sheet, you have to apply. So even when it's not as if, victims don't get represented, you have a watching advocate, etc. So you can do that. What you have to do is you have to make an application before the court asking for what we call a certified copy of the papers. And then the magistrate has to allow that application. So you have to give reasons for that. So even if, for example, if I am the victim or a first informant in a case and the judgment has been delivered and I want to file an appeal, I will have to apply for the copy of the appeal. So you have to, even if I'm represented by the public prosecutor, but I can apply for the copy of the proceedings. But here, then I have to pay the charges and I get it. But here now, what has happened is that you get it free if you have a lawyer present. Otherwise, you'll have to go through the whole process, which is there in place. But if you have a lawyer present in the court, then you get the free copy of the charge sheet. But I think that the police has been asked to give copies of the charge sheet for both the victim as well as the accused. So I don't know whether the magistrates or the sessions court judges are going to take a very strict view by saying that only if you have a lawyer you will be given, because if a copy is already given to the court, they may just give it to you for free of cost. Otherwise, you have to pay for each page as per the certified copy provisions, the payment, the charges which are there, you have to pay that and you get it. So that is there. So we also that, we have a witness protection scheme, which has been framed because of Supreme Court judgment. No, no. It does not hold when the victim is represented only by a public prosecutor, because it is specifically written by an advocate. But it could be argued that because the public prosecutor is not really the advocate for the victim or the advocate for the complainant, the public prosecutor is for the state. So, and you are generally being represented by the public prosecutor who has a copy of the charge sheet. But, if you have good relations with the public prosecutor, you kind of tell that person that I want a copy of the charge sheet. What he may do is he may give you the copy and you may have to photocopy it and give it back to him. So the expense of photocopying will actually be on the victim, but this way you're getting a free copy. So, there is actually, it should have been just said that, it should be given to the victim, but the idea must be that if the victim is happy being represented by a public prosecutor, then why should we give another copy to the victim separately? But if the victim has a lawyer and wants to be represented by an advocate, then that advocate needs a copy. So it's more like from that kind of a rationale that, the copy provision must have come in. And the victim protection scheme has been framed, consequent to Supreme Court judgment, which is quite extensive, which provides for, safety of the victim, for even like, witness protection scheme, which requires a new identity, etc. So all that is there in that witness protection scheme. So here they've said that state government has to frame a witness protection scheme. But right now, because of the Supreme Court judgment in Mohinder Chavla's case, I think, in 2019, this has been, the witness protection scheme has been held to be the right of all victims, all witnesses, and it should, it is right now under 141 of the Constitution, it is part of the law of the land till as such time. So there is a Law Commission report which drafted a Witness Protection Act, but that has not been passed. So here they could have passed an act, but they just said that let it be like a scheme. Yeah. So the trial of cases, as I was saying, continues to be, both sessions and magistrates trials, and the distinction continues. And then warrants cases, police cases, even trials case of magistrates cases based on police report and private complaint, that distinction continues. Within the private complaints, the procedure for trial in warrants cases and procedure for trial in summons cases continues. Because in warrants cases, you have evidence before charge and after charge. In summons cases, you don't have charge, you have plea. So all that continues. But there are certain changes. One of the major changes is that in a summons tribal case, the accused has now been given the right to file a discharge. Earlier, you had to file a revision in the sessions court or under 482 in the high court if you felt that the case had no merit. Otherwise, in a warrants case, you had that you could file for discharge. In a police case, you could file for discharge. In a sessions case, you could file for discharge, but in a summons case, you couldn't file for discharge and you had to go to the sessions court. Now that right has been given to the accused. There were judgments of the Supreme Court which gave the right, and then there were judgments which took away the right. And now again, it's come through statute. Yeah. Yeah. Yeah, I'll be dealing with that. So the thing is that the accused has to file discharge within 60 days of framing of charge, which is a contradiction. These are magistrates' cases. So the thing is that generally what happens is that the stage for filing for discharge comes before framing of charge. Framing of charge is when the judge is going to begin the trial. After the charge sheet is filed, decided to start the trial. At that stage, he calls the accused and he asks him, "Is the charge against you and do you plead guilty or not?" And if the accused says that I plead guilty, I accept the charge, then he's convicted and there's no trial. But if he says I plead not guilty, then that will be a trial and then the whole process goes on. So the idea is that once the charge is framed, then the witnesses are called and the trial begins. So the stage of discharge always comes traditionally before framing of charge, and it does not come after framing of charge. So that has been the thing that you cannot file, and there are judgments which say that you cannot. Suppose like I didn't have a lawyer and I was called and I framed charge, and then I went to a lawyer because next date my trial is going to start, and my lawyer looks at the papers and says, but there's no case against you at all, so why should you go through a trial? And so my lawyer makes a discharge application at that time. There are judgments which say you cannot file discharge after framing of charge. Then you have to go through the trial. And you will get an acquittal or a conviction, but discharge only happens prior to framing of charge. So this kind of filing of discharge within 60 days of framing of charge is like a very confusing thing because you've tried to put in timelines, but actually if a judge has framed charges, he's going to start the trial. So can I now file a discharge after 3 witnesses or at the stage of argument, because on the ground that it's 60 days of filing of framing of charge. So this is like something which I don't know why, even after the standing committee looked at it, why did it still come back in the same form? That is one thing. The other is that framing of charge within 60 days from the date of first hearing on charge. Yes. Yeah, I know. I know what your question is. I'm coming to that. The framing of charge is within 60 days from the date of first hearing on charge. So actually, anybody who's actually practicing knows that there's no such thing as a first hearing on charge. There's no hearing on charge. The whole idea is that you either file for discharge or you don't. You just get dates and then you're told the public prosecutor is asked to file draft charges. So that is the only thing that the judge will keep it for framing of charge and ask the prosecutor to submit draft charges. And then does it mean that the day the prosecutor is asked to file draft charges is your first day, and within 60 days you have to frame charges? And what happens if you don't do it? Because I can understand that the accused right lapses if the accused does not exercise it. But if the prosecution does not keep to the time limit, or a judge does not keep to the time limit, does it mean that charges are not going to be framed and the accused is going to be discharged? Obviously not. So one doesn't know what the purpose of actually giving this timeline, except to say that, we're trying to set timelines and we're going to, because then you should have set a timeline saying that from the time of framing of charge till the judgment, it should be done within 60 days or 90 days or 1 year. Then it makes sense, But if you're saying that you frame charge within first date of, because after framing charge, you don't have a trial. You can continue to keep it for prosecution evidence for 1 year, 2 years. There is no time limit for the trial to get over after framing of charge. That should have been actually done. Then, of course, statements of witnesses who are in the court can be done audiovisual means. Yeah. Yes, it means that you don't have to file a revision or go to the High Court. So the thing is that if in a summons case, which is 6, magistrate can discharge if the accused, if he finds that accusation is groundless. So that is the discharge means that there's no case made out against me, and that's why should I go through a trial? So generally, it is there in every case, and it's not there in summons tribal cases before a magistrate based on a non-police report. When it's a private complaint, that right is not given to the accused. But many of the accused, anyway, once you're issued summons and you come before the court and you say that, but there's no case made out, and why should I go through trial? Then you challenge the issue of process by way of a revision or quashing of the complaint under 482. Now you can file it over here. Though there is no such thing as a charge framing, plea will be recorded. So according to me, it has to be done before plea is recorded. So anytime before plea is recorded, you can ask for discharge, and you don't have to file a revision or go to the High Court. So this is actually a good thing that has come to in the hands of the accused, because it's going to declog the sessions courts and the high courts of their revisional jurisdiction. But of course, it's going to clog the magistrates courts, which are already extremely burdened. Yeah. Yeah. The other thing is that, in a private complaint, I don't know how many of you are familiar with this. So suppose like the police is not taking up my case, I go and file a private complaint, or in a non-cognizable case, I file a private complaint. So the magistrate will, what we call, goes through a verification process, so calls the complainant and takes the statement of the complainant, sees the documents produced along with the complainant. And if the magistrate feels that there's a case in which it's a cognizable offense and the police should investigate, then, I don't know the new provision, but the old provision 156(3), the magistrate makes an order saying that the police should investigate and file a complaint. Then there is other provision called Section 200, where the magistrate himself inquires into the case. Earlier, it could be done through the police also, but now it is under 202. But now there are Supreme Court judgments which say that the magistrate has to do it himself or herself. There are judgments which say that at that stage, till the accused is process is issued, that is, summons is issued to the accused and he's called to the court, he cannot be heard. So I come to know that a complaint has been filed against me. I can't go in the court and say that you have to not issue process in this matter, and you have to hear my side before, and not just the complainant's side. But now this provision has been added that the accused can be heard even before issuing of process in private complaints. And in case of police, then the report has to be called for from the superior officer, and the police has to be heard before issue of process. So this right has been given to the accused in private cases. Then the other change which has come is that we all know that there are warrants tribal cases and summons tribal cases in private complaints. And then there is a third category, which is summary trials in cases which are punishable with less than 2 years. In the code of 1898, it was 1 year, then it was increased to 2 years. Now it's been increased to 3 years. And this law says that any case of theft or stolen property matter relating to stolen property, receipt of stolen property, etc., after the 20,000 rupees can be tried summarily, or any case which is not punishable with. So here, basically, it's not a whole trial process. It's done in a justice stove, and it's done in a very quick fix way. So where the rights of all the your stages of trial are not really gone through. So that is something which many people uh, are having issues with. The other is, of course, sessions tribal cases more or less remains the same. Committed here, there's again a timeline brought. So in a sessions tribal case, not in POCSO cases, because POCSO there is a special court, so the all the stages take place in the special court. But in a regular, suppose it's a murder case or it's a rape or murder matter or whatever, then it'll be before a sessions court. So the charge sheet is filed before the magistrate, and the magistrate commits the case to the sessions court for trial. So there was no time limit for the committal proceedings. Now it is done. It has to be done within 90 days, and it can be extended up to 180 days for reasons to be recorded. Then within 60 days of filing of the matter being committed to the sessions court, the accused has to file for discharge. So after that, the accused doesn't. So even if like my trial doesn't commence for 3 years, and I'm in jail and I don't even know my matter has been committed because I haven't been produced, like we have clients who are not produced for years in court. And but the thing is, I lose my right to actually file for discharge if I don't do it within 60 days of committal. So this setting up of certain timelines, which are actually not going to affect the time taken for trial, becomes quite meaningless. Otherwise, why don't you say that within 6 months of committal, complete the trial, or within 2 years of committal, complete the trial? But that has not been set up because obviously the courts don't have the time. Then statement of witness again can be recorded through audiovisual means, and judgment has to be delivered within 30 days of completion of arguments, which is extendable to 60 days. But again over here, if it is not done, then all the consequences are going to be that you're then there are some important provisions relating to trials. So as I mentioned earlier that sanction for prosecution of public servants continues, but deemed sanction within 120 days. Trials can be held in electronic mode. Documents, so any document which is filed, produced in the court, generally the maker of the document has to come and prove it. Tomorrow Medha will be doing it in a little bit more detail. But what happens is that at the time when charge is framed and when the trial is going to begin, generally the public prosecutor files an application under the old 294 CRPC, where you give the list of all the documents so all your panchnamas, your medical reports, your postmortem reports, everything is there. The list is there, and the other side is called upon to admit or deny the documents. So the accused lawyer will either say that, okay, suppose like, for example, the scene of offense panchnama has been done, or the dead body has been sent for postmortem, and I am not going to challenge that. Then I will admit that document, and I may not admit certain documents, like, for example, recovery from me. So I may not, or my fingerprints or blood samples, or in my medical report, I may not admit that. So I have the right to decide which documents I admit, and then the witness is there. If I admit a document, the witness is not called. But if I don't admit the document, otherwise the witness has to be called. Now here, what they've done is they put a time limit on admission or denial of the document. So within 30 days, I have to admit or deny. And if I don't deny it, then the witness will not be called and not be examined unless only qualifier for an expert witness to be called is if the report is disputed. Otherwise, there will be no this thing, and there is a time limit for you to dispute it. So if you don't dispute it, so it severely impacts fair trial, especially when it comes to poor accused who have no lawyer and who are finally produced in court, and they will finally at the time of trial, when they decide to not plead guilty, because there's a Supreme Court judgment which says that a trial without a lawyer is vitiated. Therefore, you appoint a state-appointed lawyer who may not be in court on the last day within that 30 days that the person has to be disputed. So these are rights which severely impact, the rights of the accused. In case of documents prepared by any public servant, scientific expert, medical officer, or investigating officer, his successor in office may be called to give evidence if he's not available for any reason, such as death. He's been transferred, or he's unable to come, or he's not well. The successor in office can come. No adjournments to be granted during trial, except if they're beyond the control of the party, after hearing objection of the other side, and then again, not more than twice. If a witness does not appear, this is another very important section. It's there in another slide, I think, that I'm going to deal with tomorrow, unless it's in the next. If a witness does not come and the judge can close the evidence for cross-examination, the judge can tell the prosecutor that if the person does not appear, then the judge can close the evidence, and the witness's statement will be as if the statement has not been recorded if the person has not been cross-examined. And then the judge will give the evidence. So that is one other provision that has been made. Then the 5 offenses of the same type in the old law, 3 offenses of the same type committed within a year can be tried together, whereas here it's been increased to 5 offenses. Then we know that if there are multiple charges and there are different sections put, there are 2 ways in which the sentence would pan out. One is it would pan out consecutively. That is, one sentence gets over and the next starts. And generally the shorter is said to get over first, and then the longer starts after that. Or it could be both go on together. So if, for example, I've been convicted on 2 counts, say, for example, one count I've got 3 years and the other count I've got 5 years. So if it is consequent, then I'll undergo 8 years of sentence. But if it is consecutive, then I will undergo 5 years of sentence, and both my sentences will go on simultaneously. Sorry. Yeah. Yeah, so, changes in a nutshell, overall structure and procedure remain the same. There are certain, changes which have come in, which are contradicting Supreme Court rulings, such as the right to handcuff certain offenders, including offenders, sexual offenders, the extension of police custody. Then there are the discharge application, the preliminary investigation. All these have been introduced. So one has to look at, when the constitutional challenges come, what is going to be the outcome and how it is going to pan out. Of course, as I mentioned earlier, if there is a contradiction between POCSO and BNNS, then POCSO will prevail. Yeah. So, for example, so Vibha has asked can one explain this 5 offenses of the same kind? So, if I have been charged, if there are 5 FIRs of theft cases against me, and all the 5 FIRs are within that particular period of 12 months, then I can be tried for all of them together. So generally it's done in petty offenses. It's not really done in say murder cases. If I'm alleged to have committed 5 murders within 12 months, then generally the trial of all the 5 will not be held together. But in many theft cases, a police station, I mean, and this is our experience also, that once a person is arrested, then a lot of unresolved cases are also, you suddenly resolve them and you decide that this is the person who has done all these things. So a person who is arrested, especially in petty offenses such as theft, there'll be like some 5-10 cases registered, in which he's arrested. So in that case, the person can be tried for all of them together. But of course, it is subject to same police station, etc. Witnesses can't be like one in Delhi and one in Ahmedabad and one in Guwahati. That's not going to work out. Up to 5. Up to 5. Yeah. So yeah, this, we've already looked at this unsoundness of mind. That is an important change. Then scope of admissibility of forensic evidence has expanded. Dispensing of evidence of experts of documents unless disputed. The scope of what is the primary evidence has been expanded because of electronic things, because you can't, the original, it's like a book, so they've said that anything, like, for example, the original has to be always produced, but there are exceptions. Like, for example, a book. If a book is published and it contains, say, defamatory material, then you don't have to get the manuscript of the author and say this is the primary evidence and the published book is not. So generally copies of certain kinds are admitted. So that scope has been expanded, and it's electronic copies have been brought under the ambit of what is primary evidence. Then harsher penalties and bail has been made more stringent. So no anticipatory bail in all cases of aggravated sexual assault. Earlier it was for child rape. Now it is for all cases of aggravated sexual assaults. Thank you. Yeah. Are there any questions?
Monica, yes. That was excellent. We will open it up for questions. So we would request you all to, use the raise your hand feature, and then we can call upon each of you to ask your questions, since we have a lot of us on the call. Alternatively, you can also drop your questions into the chat box. Monica has already answered hers along the way.
Yeah.
Most of them, and
Hello.
sorry, was somebody asking a question?
So Swagata had dropped me a message asking to on the implications of section 69. So till we receive the other questions, maybe I can just address that. Or should we wait for this one?
No, we can go one by one. Please proceed, Medha.
So the BNS introduces a new section which talks about sexual intercourse by employing deceitful means. This obviously connotes all kinds of sexual intercourse which do not fall within the definition of rape, which is under section 63. So very, very gray area, which has been earlier it has been judicially decided in multiple cases. And this decided position as of 2019 was, the courts had looked at this on a case-by-case basis, obviously. And what they had looked at was in cases where where sexual intercourse was by way of some kind of an assurance or promise, either for a job or in most cases, actually for promise, in case of false promise to marry. What the courts had looked at was whether the consent was taken under a false promise, and was the alleged offender, while giving the promise, did the offender believe that the promise was false? And this was in several judgments, the last of which was a 2019 judgment called Pramod Suryan Pawar versus State of Maharashtra. And what basically came down to was that the Supreme Court held that sexual intercourse pursuant to a false promise to marry is rape, but failing to fulfill a genuine promise to marry is not rape. So this decision itself was very, very dicey, because what happened was there were cases where marriages could not happen because of caste differences, etc. And courts had held that this was actually a person not being able to fulfill a genuine promise, as opposed to the sexual intercourse being on a false promise. So unfortunately, the section also does not clarify on what would be a false promise to marry, and or what would be deceitful intent. That definition or that clarification is not given in the section. It just says that deceitful means shall include inducement for false promise of employment or promotion or marrying by suppressing identity. But how this dichotomy of what is a genuine promise which was unable to be fulfilled versus what was a false promise is to be resolved still remains in the gray area. In terms of looking at child victims, this section will not be applicable, because in any case, the section on rape, section 63, says that any consent, any sexual intercourse, even if it is with consent for somebody under 18 years of age, will fall under the definition of rape. And since section 69 specifically talks about sexual intercourse which does not constitute rape, so this will not be relevant for child victims as such.
Thanks, Medha. I think this section also, it becomes maybe relevant because there are a lot of prosecutions under POCSO which fail because age is not determined. So then this gives an pathway for the prosecution to take, where even if age determination fails, or you're not able to establish the minority of the child, then you have this provision which is now no longer contingent on age.
Right.
Yeah, so Swagata has asked this question about, this whole preliminary inquiry in sexual assault and sexual harassment cases, and what are the larger implications of provision relating to sexual preliminary inquiry. So the thing is that, one is that if it is an offense punishable under 7 years, you don't have to arrest the person. You can even notice and tell that person to be present before you. So you have that option anyway under the CRPC. You don't have to arrest the person. Secondly, the whole point of an investigation is to actually find out whether the case, what are you going to do if you're going to, like, there should, the thing is, it's all also very discretionary. It isn't as if that you have the discretion to arrest or not to arrest. You have the discretion to have a preliminary inquiry or not have a preliminary inquiry. So, power play becomes a major issue. So even assuming that this preliminary inquiry provision was not there, as a police officer, I have the right to not arrest somebody if I believe that that person, and today I'm going to arrest anybody who I think is basically anybody who's seen as a flight risk will be arrested. So I will arrest that person. And the second issue is that uh, I anyway had the right to investigate and find out whether the whole purpose of investigation and the time given to the police is to find out, to investigate and see in cases where the accused is unknown, who is the accused. So for example, a body is found on a nala, and you get the body, you send the body for postmortem, and you find that the person has been killed, murdered. It's a case of homicide. Then anyway, you're going to register an FIR against an unknown person. You're going to investigate and you're going to find out. So that is the point of investigation, that even if you have zero information about a case, you investigate to find out. So that is your job. And if suppose at the end of investigation, you're not able to find out, you can file a report saying that it is a true case but undetected. You can say that we don't know whether it's a true or false case, or you say it's a false case, or there's no evidence against the person. So that anyway, you have the power to do it, even in cases where an FIR is registered and you start investigating. That is one thing. The other is that more and more offenses are being brought under the ambit of no anticipatory bail. Earlier, the accused also had the right to file for anticipatory bail, but now you're saying that for this offense you can't file for anticipatory bail for that offense, and at the same time you're giving so much of discretion to the police in these kind of cases. So there is a certain I mean, if you feel that a certain category of cases, there should be no arrest, say that in these cases, there should be no arrest, because earlier the provision was that within 7 years, if you're arresting somebody, you have to give reasons. Now it is that if you're not arresting somebody, you have to give reasons. So, the discretion is also, in some ways it's being narrowed, in some ways it's being broadened. So I feel a little discomfort about the preliminary investigation process, because it could be, it is not going to be the genuineness of the case or the type of case or the type of allegations which is going to determine, but other factors which is going to determine. Yeah. So, elaborate on the medical expert testimony dispensation. Okay. So the thing is that what the provision says is that if a report is filed, then the court has a discretion to call the maker of the report. Any scientific report that is filed in the court as evidence, the court has a discretion to call or not call. So that option has been given to the court to not call or call. That is one thing. The other is that if I do not dispute, so apart from the fact that whether even if I don't dispute it, the judge feels that no, I feel the need for this particular witness to come and give expert testimony, then I have the discretion to call the person. So that I'm sorry, I didn't actually specify that in the slide, but that discretion is there with the court. The other is that suppose the court doesn't see any need to call the expert witness, then if the accused has not demanded that, disputed the veracity of that particular document and said that, I want to call that witness, then the witness will not be called. That is one thing. The other is, I put the slide on rights of the accused and how they are compromised over here. But one of on arrest that I was planning to do tomorrow. But one of the things is that the court has a discretion to, this whole thing of self-incrimination and the right against self-incrimination has been a major part of our constitutional scheme of rights of the accused. And that the whole question came up that does forced testimony comfortable sharing? Yeah, sure. So, yeah, I'm okay about sharing. I'll share my PPT. I'll send it to you all, and you can share it to the participants. And I don't know, the contact details can also be shared. The thing is that, yeah, the previous question, I was just, yeah. Yeah, so the thing is that the whole thing of, is compelled testimony, does that include, fingerprints? Does that include signature specimens? Does that include blood samples? What amounts to testimony? And the Supreme Court has basically said that, you can be asked to give your fingerprints, you can be asked to give your, signature samples, etc., your handwriting samples, etc. All that is not covered under compulsory testimony. But then we had the narco analysis judgment, Sylvie versus state of Karnataka, where they said that, you can't be compelled to, go through a narco analysis. So there has been, but of course, medical evidence has been allowed, and it has been brought in the CRPC, permitting that the accused should be made to undergo medical evidence. So now the thing is that earlier it came as a right under D.K. Basu's judgment, where they said that in order to prevent torture, every accused has to go through medical examination every 48 hours of arrest, immediately on arrest, and every 48 hours. Now it is under this, and that is a Supreme Court judgment. And now what you're saying is that you will be made to undergo a medical examination and any test that the IO requests the police to do, the medical officer to do. And once more, you can be asked to do a medical examination. So you've done away with the 48 hours. You've done away with, so you now does that amount to post testimony being asked to give? So, your DNA sampling, everything has already come in. So I really, I feel that it's going to lead to a lot of challenges, but I don't know which direction things are going to go. So because Sylvie versus state of Karnataka was a bit of a anomaly in terms of the kind of judgments which are generally emanating. So that is one thing. So yeah, there is mobile.
Monica, Shruti Raman is a question. If
Yeah, this whole right.
Shruti, you want to ask?
Yeah, Shruti's question on, how is it going to impact the rights of victims in sexual offenses and sex trafficking? That is something that, a lot of people have been talking about the rights of victims and right to privacy and your confidentiality being compromised when it comes to this. The thing is that the way I look at it, the victim has the complainant has the discretion to say, I don't want it. I don't want it videographed. I don't want it photographed. But I don't know whether the accused won't have a similar right to say, I don't want this or I don't want that, because you're in custody and you can be compelled to do anything. Whereas a victim can still say that I am not comfortable and I don't want it done. But yes, most of the people are not going to say that. Most of the people are not going to be asked that. And then the compromise of, is, yeah. Who's, okay. Were you all able to hear me?
Yes, we can hear you. Yes.
Oh, okay. Did you all lose me for some time?
No,
Okay.
all good. Feel free to unmute and ask questions.
Yeah.
Sorry, I just wanted to add to what Monica was addressing in the previous question. Section 72 of the BNS, like the old IPC, will continue to give protection against disclosure of identity of victims. So, in that sense, victim will still have protection against disclosure of their identity or any identifying information.
No, but I think what she was trying to address was that if you're going to record my statement, which were to the police under the law, then how do you prevent its misuse, and how do you ensure that it is, protected in some way, and it doesn't leak out and doesn't make it to TV channels, That is, I think, what she's.
Or that, because if it's on a mobile device, it's easier to share and
share it and, shame the victim. Yeah.
Swagata has a
That
question.
device thing is, I think they tried to kind of resolve it by thinking that, otherwise everybody would have said, how is this kind of technology going to be made available to everyone to record things and all that? But they don't, so they must have really thought that, oh, everybody has a mobile phone, so it can be done. But then how do you actually preserve so one of the major issues which is being actually spoken about is that how do you actually ensure that it is not tampered? That is the major question, that because if you're going to actually allow any electronic evidence to just walk into the thing, without questions asked, then how are you going to ensure that it is actually not tampered? That is one thing. The other question that is actually coming in a lot is that, from the date on which the law comes into force, especially now, like suppose an offense is taking place today and one goes to the police station on Monday, then which law will apply is the other question, which is there's no provision for child data protection and data management system in place. Under the IT Act, there are provisions, you can prosecute. Our whole regime is prosecute rather than actually put in systems in place to ensure safety.
Swagata has a question. So she's asking, Monica, could you please share your perspectives on Section 219(6), where no court shall take cognizance of an offense under Section
64, under Section 64.
4 of the BNS, where such offense consists of sexual intercourse by a man with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from the date of the commission of the offense.
See, the thing is that the 319, no, actually was actually meant for offenses against marriage. So 19, it's the equivalent equivalent law was advice. This is 319 or 219? 219. No? It is 219, no? Prosecution in marriage. Actually, it was.
Yes, 219.
Yeah. So actually, the original provision was, the adultery and those sections. So they had just, so it was that chapter, I think chapter, let's see, IPC. it was a chapter on offenses relating to marriage. But now those offenses relating to marriage have been brought into this chapter, chapter 5, which is offenses relating to women and children. And they have basically, not made a distinction. So the thing is that it is really, bigamy and, kind of going through a fake marriage and or adultery or, those are the provisions that actually were governed by this particular provision under the earlier code. And so I really, I think it is an error, and I don't know whether it will really apply. One can argue saying that it will apply to offenses under section 65, where the under 64. Where there's a it's between husband and wife, and it's a case of where the woman is which is the exact proviso that you're actually referring to?
Yeah, I think Monica, I was referring to, what what Medha also said, no, that section 64 now reflects the judgment of the Supreme Court in independent thought. So exception 2, exception 2 now, makes that point about sex with a wife below the age of
Okay.
18, right?
63, yeah, 18. Not being under 18 is not rape.
Yeah. So
Yeah.
now if we read, now they talk about the punishment for rape is 64. And then this provision in the CRPC which says that you cannot file a complaint. No court shall take cognizance of an offense where such offense consists of sexual intercourse by a man with his own wife being under 18, if more than 1 year has elapsed from the date of the commission of the offense. So I was just trying to understand, in what circumstances this may.
Where is what are you reading exactly?
I'm reading section 219, subsection 6 of the BNNS.
6, okay. Okay.
But I'm reading it with section
64 of the,
Yeah.
yeah. Okay, more than 1 year has elapsed. Okay, yeah.
But
It is going to impact if it is more than 1 year, then yeah.
So this effectively means that marital rape will be recognized only if it is reported within 1 year of the.
No, it's actually going to mean that if it's a child marriage, then you can only file a complaint within 1 year.
Yeah.
that's right. But the thing is, in the context of, say, consensual cases or factually consensual cases, where sex is going to be continuing. I mean, I'm curious to see how this plays out. Whether this bars, reporting of any kind. Because many of these things come to light when the girl goes to the hospital for pregnancy care. So maybe.
But if I'm say 17 when it happens, and after I turn 18 and I'm now 19 years old, I think that continuing offense will end once I turn 18, no?
Yeah, I'm still looking at where she's below 18. Or say
She's
hit 18.
and then now she's 17.
Or she's hit 18, but
yeah.
the sex took place.
Then anyway, POCSO will also apply. It won't be just this section, no?
Yeah, so this section will not prevent the application of POCSO.
No, it will not prevail over application.
But then I think what happens in a way that what section 64, exception 2 was trying to remedy, sort of gets frustrated for this limited point of marital rape and where the offense is not reported within a year.
See, the thing is that actually, if you look at even the provisions with regard to sexual assault, it's a whole missed opportunity because you had the choice of expanding the scope of what amounts to consent and what does not amount to consent. Because you've still not brought in fraud. Fraud you brought in only in promise to marry or through disdain, which you've given a lesser punishment to. So fraudulent sex, but you're still saying that if he is not her husband, but she thinks he's another man who's her husband, you're still continuing with that. What does that mean? And you've not brought in marital rape of adult women who are saying that I was forced to have sex. A minor may not be forced to have it, may be consensual. No, so if I'm 17 years old and I'm consenting to sex with my boyfriend, that is rape. Whereas if I'm 19 years old and I'm actually getting raped by my husband, then that is not. So I find that there's a it's a huge missed opportunity where they could have brought in the age difference. There are so many things that they could have done, with the sexual offenses thing. But they didn't do it. They could have relooked at the whole idea of what is consent, what is not consent, what amounts to consent, what does not amount to consent. That you haven't really done that. You brought in promise to marry as a subset, as a smaller kind of this thing. And as Medha was saying, the Supreme Court judgments are going to just stand in the way to what amounts to, an offense and what does not amount to an offense. So, yeah, because is a fraudulent consent, less problematic than intoxication and then getting consent? I don't know. I just have these questions.
Anandita has a question. I'll just read it out. Does it make any material difference that kidnapping of a woman for the purpose of marriage is moved to the chapter on offenses against marriage from the chapter on offenses against the body?
No, I would say no, because most sections have been just rearranged in a way that, I mean, for lack of anything better, that just made sense to the people who were drafting it. I don't think moving it from chapters here and there will make any difference in the implementation. I'll just quickly check to my best knowledge. There's no material change in the. Yeah, there is no change in the language of the section. The only change that is there is minor has been changed to child. So yeah.
Any further questions?
Comment about POCSO section 5 was in relation to the previous question on 219, I'm guessing.
Yes.
So I had a small question, Shruti. So just a general thought, because I haven't read all of it. So is this change from minor to child, is it sort of standardized throughout? Or
Yes.
is there some, so that's been done across the board in
the BNS, I mean, yeah, to the best of my knowledge, it has been made child everywhere, Namisha.
Thanks.
And the intent is to make it child everywhere. So there might, I mean, I could still see a few clerical errors, but I think the intent is to make it child everywhere.
I'll just read the next one. Is there any provision for the court to investigate if a crime or witness turns hostile during trial in a sexual assault case, as to why they turned hostile, whether under threat, settlement, family pressures, loss of hope? I think this topic has gotten a lot of heat lately, mainly in the context of, rape trials where victims are turning hostile.
Yeah. there's no substantial change with regards to all this. Actually, there is nothing in the CRPC or in the existing law, to prevent a court from taking cognizance or asking the police to register an FIR if they feel that an offense has been, or calling the victim to the chambers and talking to the victim, or appointing asking the police to file a report as to why the victim is not coming, or to ensure that witness protection schemes are put in place in cases where the court is of the view that the person is under some kind of a threat. So there are already these kind of provisions which are there, but they're not being used really. So there's nothing to prevent the court from actually taking cognizance of these things.
So there is different definitions of child. As you know, ITPA has both child and minor.
Yeah.
Whether these differences are going to affect implementation. Ranu is asking this.
I think in terms of punishment, the higher punishment will prevail. And wherever there is a minimum mandatory under the IPC, that minimum mandatory will prevail.
See, generally, when they register a case, they register it under both ITPA as well as the the general law provisions. So anyway, so if 370 is added, then now the new 370, then anyway that will also the punishment under that will apply.
No, also ITPA defines the age of child as 16 and not 18. So I think in that sense, the Bharatiya Nyaya Sanhita will apply to everybody who is under 18 because it's more beneficial.
But for minors 16 to 18, that won't be the case, no?
No, so the trafficking provisions which are in IPC will apply to everybody who's under 18. Even that 16 to 18 category will fall under that.
Right, but I was thinking, since ITPA is the special law here, will it prevail over the IPC? Does that not happen?
Special law will prevail if it has higher punishment, not lower. I think if general law has higher punishment, that
Okay.
will prevail.
Okay.
See, the thing is that it is not a question of prevailing. Like, for example, if you're putting a section of POCSO, you're also adding 376 along with
Yeah.
not just writing, 8 or 6 or 8. You're also writing read with 376 IPC. So you're actually using all the sections which fall, which make it an offense. So if one particular section doesn't make it an offense, see, like it's like saying that if POCSO doesn't apply, won't IPC apply? Of course, it will apply if you fall under that.
I have a question. I was curious to know, Medha, you had put this slide that, voyeurism and I think
Attempt to disrobe.
Disrobe were made gender neutral. But when the 2013 criminal law amendment, the voyeurism, stalking, I think sexual harassment, all of these were introduced together.
Right.
But why was only voyeurism made gender neutral, but not these offenses that were, legislated together at that time?
I do not have any insights on that. So it's only these two which have been made gender neutral for the accused. The victim still remains a woman.
Oh, okay, right. Oh, I thought it's made gender neutral in respect of both the
No.
the accused.
It's gender neutral for the accused only. The victim is still woman.
Okay. I'm wondering whether it has something to do with like for voyeurism especially, there's a we're seeing an increase in number of cases through, videos and
Yeah,
the
where
use of
women are
mobile
involved. Yeah,
and where women are also. Mm.
yeah. It could, I mean, logically, that's where it's coming from. But I mean, not that otherwise men do not get victim to voyeurism. That's not, I mean, that also comes through, but yeah.
Thank you. Yeah. Okay. Any last questions or we can close? Okay, then. So we will break until tomorrow. Tomorrow it's between 4 to 5:30 p.m. Please do let us know if you have a confusion with the meeting link or the ID. It has been shared once in the chat box. I'll just ask my colleagues to share it once again right now. Tomorrow we will be dealing with the law as it impacts children in conflict with the law. Thank you so much, Monica and Medha. This has been really useful and helpful. And if anyone has any questions they're sitting with, maybe they can ask tomorrow as well. Yeah. Thank you. The meeting ID and link have been shared. So if any of you want to make a note of it for tomorrow, that'll be great. So until tomorrow at 4, see you.